Are Arkansas sports waivers enforceable? What parents need to know about negligence claims for minors. Many parents sign liability waivers for their children at trampoline parks, amusement parks, water parks, or other recreational facilities in Arkansas, believing these forms are standard and required. These documents contain dense legal language that appears to release the business from responsibility if an injury occurs. When a child is hurt, families may still have the right to seek compensation even if they signed a waiver. Little Rock child injury claims lawyer Joseph Gates and the Gates Law, PLLC law firm explain why these waivers may not always hold up. Recreational facility waivers are contracts designed to shift responsibility to families by including exculpatory clauses, releases of liability, and indemnity provisions. These provisions ask parents to agree not to sue for injuries, surrender legal rights, and even reimburse the facility if someone else sues. Businesses rely on waivers to deter lawsuits and to document that you were aware of inherent risks. Arkansas courts disfavor exculpatory agreements and strictly construe them against the drafter because they allow a party to contract away its duty of reasonable care. A minor lacks legal capacity to enter a binding contract, so parents cannot bargain away a child's right to sue and recover damages. Public policy protects children and discourages enforcement of waivers that would remove incentives for facilities to maintain safe conditions. The Arkansas Supreme Court recognizes that the child's best interests are paramount. For minors, Arkansas liability waivers are generally not enforceable, and families may pursue negligence claims even after signing one. Evidence that an injury resulted from hazards not listed in the waiver can help prove negligence against a facility. Courts distinguish between inherent risks and actionable negligence when evaluating recreational facility injuries. Inherent risks are normal, foreseeable injuries that occur even when staff are attentive and equipment is safe, such as minor sprains or bumps on rides. Negligence is the failure to exercise reasonable care, like not repairing broken equipment or providing enough lifeguards, and such failures create risks beyond those inherent to the activity. To prove negligence, the injured child's attorney must show that the facility breached its duty of care and that this breach caused the injury. Facilities owe duties to provide proper supervision, maintain safe equipment, conduct inspections, instruct participants, have emergency plans, and train staff. Arkansas recognizes degrees of negligence, and waivers cannot excuse gross negligence, reckless conduct, or intentional harm. Common negligence claims arise from inadequate supervision, unsafe premises, defective equipment, poor training or staffing, and failure to provide appropriate medical care. Joseph Gates founded Gates Law, PLLC in 2020 and represents children and families injured at Arkansas recreational facilities. He serves on the Board of Trustees of the Arkansas Bar Association and is active in the Arkansas Trial Lawyers Association and the American Association for Justice. Signing a waiver at a trampoline park, amusement park, or recreational facility does not mean giving up your child's right to safety or justice. Arkansas courts have not definitively ruled whether a parent's pre-injury waiver for a child is entirely void, but they strictly construe any release that attempts to waive a minor's rights. If your child was hurt at a facility in Little Rock, North Little Rock, or anywhere in Central Arkansas, consult a lawyer experienced in Arkansas injury law and recreational facility operations. The Gates Law Firm PLLC, located at 2725 Cantrell Road, ST 200, Little Rock, Arkansas, 72202, United States, offers free consultations and can be reached at 501-779-8091. Talk to an attorney there to pursue justice for your child.